Hello, my dear listeners. This is your bar exam coach. I am attorney Jennifer Estabilio. Our topic for today is about legal forms and practical exercises. This is part of your legal and judicial ethics. So this is part of your bar examinations. Before we go into the legal forms, let us first discuss the fundamental qualities of good legal writing. A good legal writing should be clear, concise, and direct. Just like in answering your bar examinations, your answer must be concise, clear, and direct. Avoid unnecessary details, avoid unnecessary words. So what makes legal writing clear? You should use proper grammar and punctuation, use plain language and simple sentence structure, use active voice instead of passive voice, avoid vague and ambiguous language, and use jargons wisely. For proper grammar and punctuation, as we all know, plural subjects take plural verb, while singular subjects take singular verb. For example, the parties of the contract are bound to fulfill their respective obligations. Okay, so since there are many parties, you should use are and not is. Another example, the buyer pays the purchase price. The buyer is singular, so use a singular verb. Okay, so this is very basic, and I'm sure you know this by this time. What else? Use of present tense or past tense consistently. Example of present tense, the defendant breaches the agreement and causes damage to the plaintiff. The plaintiff seeks relief from this court. So the present tenses here are as follows: breaches, causes, and seeks. So use present tense consistently. However, if you will use past tense, use it also consistently. For instance, the defendant breached the agreement and caused damage to the plaintiff. The plaintiff filed an action for relief. Here, the past tense are breached, caused, and filed. Okay? So be consistent. Next, capitalization. However small a matter, correct capitalization affects the reader's overall impression of the work. Capitalization is also important in writing to show readers the importance of specific words and to indicate change in meanings. Example, when referring to a specific act or law, you should write RA 9262 is also known as the Anti-Violence Against Women and Their Children Act of 2004. So you need to capitalize the first letters of the title. Okay, and then you also need to capitalize R and A. Okay. When referring to a specific code, for example, according to the revised penal code, so you need to capitalize the first letters of the revised, letter R, penal, P, and then the code, letter C, because that pertains to a specific code. However, do not capitalize when referring to codes generically. For example, the inspector cited the landlord for numerous code violations. So this is general, okay? Code here is cited generically. So you do not need to capitalize the word code. Next, about punctuation. Okay, so what if I told you punctuation is your friend? Proper punctuation marks in legal language are crucial because they can significantly alter the meaning of a legal document or statute. Legal documents are often complex and precise, so even a small mistake in punctuation can lead to misunderstandings, disputes, or unintended consequences. For example, the use of commas can change the meaning of a sentence entirely. So remember your statutory construction. Okay, so if you place your commas differently or you did not place your comma, then the sentence meaning may change or it may be altered. Okay, so for example, the defendant, comma, who was not present at the scene, comma, is innocent. While in the second sentence, the defendant who was not present at the scene is innocent. There is no comma there. So what will be the meaning of these two sentences? Okay, in the first version, the defendant's absence is an additional fact that does not affect the conclusion. Meaning, even though you remove the phrase who was not present at the scene because of the placing of comma before who and before the word is, it does not affect the conclusion. The conclusion is the defendant is innocent. Okay, however, in the second version, it implies that only those who were absent from the scene are innocent, which could alter the meaning dramatically. So there is a qualifying circumstance or condition in the second sentence, which is about the presence of the defendant. Okay. So be careful in placing punctuations. So it depends on what you want to convey to your reader. Another example here, let's eat grandpa. So there's no comma in place. Okay, while in second sentence, let's eat grandpa. Okay, so correct punctuation can save a person's life. Why? Because in the first sentence, you are telling that you will eat grandpa. Okay, so that's very morbid. While in the second sentence, because you place now a comma, you are just calling your grandpa to eat, right? What else? We're going to learn to cut and paste kids. Okay, because there is no comma before the word kids, okay, the meaning of this is that you are going to what? Learn to cut and paste the kids. Okay, so that is also very morbid. Okay, so commas matter. Okay. Next, use plain language and simple sentence structure. Use familiar words and avoid fancy or high-flown language or the highfalutin languages. So you may use the word fight instead of altercation, roomy instead of capacious, chat instead of confabulate, predict instead of prognosticate, and shout instead of vociferate. Okay, so use only simple and familiar words. This rule is also encouraged by the Supreme Court in their style book guide. Okay, so that is also discussed there. You don't always have to use big or excessive words to sound smart or convincing. Sometimes, the best way to get your point across is to use the simplest words. Okay, keep it simple. All right. Another rule is to use active voice instead of passive voice as a general rule. The general rule is to write your sentences using the active voice. When the active voice is used, the subject of the sentence is the actor or the doer. Example of the passive voice first. So for the passive voice, the appeal was dismissed by the court. Okay, so this sentence indicates that the appeal was not credible because the focus of this sentence is the word appeal, right? However, when you convert it or transform it into active voice, now the court dismissed the appeal, so it tells us what the court did. You are now focusing the action of the court. The court dismissed the appeal. So it is encouraged to use active voice instead of passive voice. Another example, here in Macdo, instead of it is being loved by me, No, walang dating because that is in passive voice. You should use active voice. I'm loving it, right? Because you are the subject. You love McDo. Okay. However, in every general rule, there is an exception. You may also use passive voice. For example, when the actor is unknown or unimportant, or when you do not want to emphasize the actor's conduct. Okay, so for the first instance, actor unknown, a portion of the transcript was lost. Okay, so you do not know who lost the transcript. Okay, so you may use passive voice. No? A portion of the transcript was lost. Second, actor unimportant. Okay, the passbook was found by a passerby. Here, the actor was the passerby. He found the passbook. Okay, however, the passerby's presence is not significant, but the focus of this sentence is the passbook. Okay, so you may use passive voice. Okay, the passbook was found by a passerby. Another example, you want to de-emphasize the action of the actor. For example, the vase was broken and the plaintiff was injured when the vase slipped from her hand. In this example, actually, it was the plaintiff who broke the vase because the vase slipped from her hand. Okay, however, you want to de-emphasize the plaintiff's action. So you converted it into passive voice. The focus now of this sentence is that the vase was broken. Okay, and that the vase slipped from plaintiff's hand. Okay. In legal writing, you can use the passive voice to detract attention away from a certain detail. For example, in active voice, the defendant breached the contract when he failed to deliver the goods on time. So when you use active voice, the doer here is the defendant, that the defendant breached the contract. However, if you want to detract attention away from that act of the defendant, from that breach of contract, you may use passive voice. The contract was breached when the goods were not delivered on time. Okay, now the focus here is that the breaching of the contract. However, the defendant was not mentioned. Okay, so that is the one of the ways to de-emphasize the actor's act. Okay. Another example here, an error has occurred. I'm saying this in the passive voice to avoid taking any personal responsibility. Okay, so instead you are telling that you made that error, you are now talking or saying in passive voice to avoid taking any personal responsibility. Okay, so it depends on your writing style, or it depends on what message you want to convey to your readers. However, as a general rule, and if you are going to write pleadings or other legal forms, okay, especially in your bar examination, it is encouraged to use active voice. Next, avoid the use of vague and ambiguous language. A word or phrase is vague if its meaning is not clear in the context. For example, the complainant's condition was serious when he went to the prosecutor's office and met the respondent. Here, does the condition refer to the complainant's health, his behavior, his problems, or something else? Because the condition, as worded in this sentence, is not clear. Okay, the complainant's condition was serious. So what kind of condition? So avoid using phrase and ambiguous language. Always be direct, okay, and clear. Okay. And then use jargons wisely. Good legal writing is characterized by an absence of unnecessary jargon. Take note of the word unnecessary. Why? Because there are legal jargons that are necessary. Okay, what you should avoid the use of unnecessary jargons. So law works best even for lawyers when non-lawyers can make sense of it. Okay, if the non-lawyers can understand what you are trying to say, then you did a good job in your legal writing. The role of legal writing is to communicate, not to obfuscate. What else? Use language that the readers understand. Remove legalese as much as possible. So remove unnecessary legal jargons. Resort to legal terms only when there is a need for precision of language. Okay. Like for example, instead of John has to establish inter alia that the papers were delivered, you may use this instead. John has to establish, among other things, that the papers were delivered. So make it simple. Okay, make it more understandable. Okay. What else? Instead of judgment is hereby rendered, you may use judgment is rendered. Okay, you may remove the word hereby. Okay. What else? Instead of Mr. Noto signed the contract, said contract specified a price and a schedule of payments. So these two sentences, you may combine these two sentences. So you may use instead, Mr. Noto signed the contract that specified a price and a schedule of payments. Remove the word said contract because these are what? Redundant, superfluous. Okay. What are other legal writing tips? So before you start writing or reviewing your practical exercises for the purposes of your bar examinations, you need to know these 5 legal writing tips. What are these? First, know the definition of the legal form. Of course, you need to know what the legal form or the purpose of that legal form. What's that all about? Okay. You need to understand its purpose. Para saan ba yan? Okay? What's the purpose of a deed of sale? What's the purpose of a special power of attorney? Okay? Because if you know the purpose, it will be easier for you to draft that legal form. Okay, to answer that practical exercise. Okay, if you understand its definition, if you know its definition, and if you understand its purpose. Okay. Next, you need, of course, to memorize. You need to memorize its elements. For example, the heading, the date, the body, the parties, signatories, jurat, or acknowledgement. Okay, so you need to know, you need to memorize the form itself, how that form should be presented. Okay. Number 4, take note of essential contents of a legal document. Okay. So you don't need to memorize verbatim all the contents, but you need to understand or take note of its essential contents. Okay. Because there are a lot of legal forms. So your practical exercises coverage is very lengthy. So of course, hindi mo ma-memorize lahat yan. Okay? So what's the most important thing to do? Study smart, Understand its essential contents, okay? So that you will be able to draft your practical exercises. The number 5, very important, just like taking your mock bar exams, okay? Practice writing on your own. Okay, so that is part of your review. You need to encode, as part of your review, of your practice, review of your legal forms. You need to practice writing on your own. Okay, to familiarize yourself, the placing of the elements, the contents, okay? So you need to write on your own. So as per Bar Bulletin number 1, dated September 16, 2024, so these are the coverage. So this is the coverage, okay? This is the coverage of your practical exercises. So these are your legal forms, no, that you need to memorize or you need to be familiar with. Okay, so first, the promissory notes or simple loan agreements. Second is the demand letter. Third, sale documents of either real or personal properties. Next, lease contract. Next is special power of attorney to sell a realty or appear in pre-trial. Next, verification and certification against forum shopping. Letter G, preliminary statements and attestations in judicial affidavits. Letter H, judicial affidavits in criminal cases. Letter I, notarial acts. No, you need to know the difference, no, of jurat, acknowledgement, and copy certification. Okay. Letter J, motions to dismiss, to declare defendant in default, and execution of judgment. Letter K, quit claims in labor cases. And lastly, letter L, information in criminal cases for consummated crimes, frustrated crimes, and attempt crimes. Okay, so medyo mahaba-haba, right? Now we will discuss this one by one. Okay. So I have here a bar tip. Okay. Do not write your name or any identifying details on the legal forms to avoid disclosure of the examinee's identity. So one of the prohibited acts, no, as listed in the 2025 Bar Bulletin number 4, marking of submitted answers. Okay, so these are considered markings, no, such as but not limited to, letter A, use of distinguishing or identifying marks, such as but not limited to mantras, mottos, dedications, religious or spiritual prayers, acronyms, names, made up words, extraneous text, and the like. Letter B, failure to follow the format prescribed in the exemplifying manual, Times New Roman, font size 14, or use of any extraordinary formatting. And letter C, use of any specific name other than those stated in the question, which may allow an examiner to identify the examinee. So take note of these prohibited acts. When you write your legal forms under your practical exercises, again, do not write your name. Okay? Use only the facts or the names given in the bar question or in the bar problem. If there are no names provided or if there are no other details provided, then in your legal forms, just leave those blanks, okay? Do not fill in other details aside from those stated in the question. Okay, so let's start our discussion in your practical exercises. So first, the promissory notes or simple loan agreements. So first is to know the definition of a promissory note. So it is a written instrument containing an unconditional promise by one party, the maker or debtor, to pay a specific sum of money to another, the payer creditor, either in demand or at a fixed or determinable future time. Okay, so simply stated, by the word itself, promissory note. What is the root word of promissory? Promise, right? You are promising. Okay, so what you are promising? What are you promising? Here, the maker, the debtor, is promising to what? Pay a specific sum of money to another, okay, to another person, either in demand or at a fixed or determinable future time. So that is your keyword. No, the debtor is promising something, no, to another person. The purpose of this is to, as stated, it is the promise of the maker debtor to pay for the sum of money borrowed from the payee or creditor. Okay, so these are the elements. Okay, so familiarize yourself with the elements. Okay, so the heading or the title, the promissory note, the date and place of making, the date of execution and the place of execution, the name of the parties and their personal circumstances, and then of course the body, the recital of facts, such as the amount of principal loan, Okay, the mode or manner of payment, is it installment or one-time payment? And then stipulation of interest, if any, and the requirement of a demand or at a fixed or determinable future time, and then penalties and default. And then the signature of maker or debtor, and then lastly, the acknowledgement. Okay, so this is an example of a promissory note. So you need to memorize its elements and its essential contents. Okay. So the title, promissory note, the date, the place, and then the personal circumstances of the debtor, the name of the creditor, the amount, the manner of payment, and then the interest. And then second paragraph, in case of default. Okay, so that will be subjected to a penalty. Then third paragraph, resorting to services of an attorney, okay, to enforce the note. And then lastly, that the debtor affirm and acknowledge that he or she has fully understood all the foregoing and have signed this note voluntarily and freely. And then lastly, the signature and then the acknowledgement. So this is an acknowledgement because of the voluntary and free act of the debtor to execute this promissory note. Okay, so use acknowledgement. If you still have time remaining in your bar exam, write in full details the acknowledgement, okay, the contents of acknowledgement. However, just in case you don't have enough time in answering all the questions, answering all the practical exercises, you may just use or write in parentheses the word acknowledgement, just like in this given example. Okay, but I encourage you to write the contents of the acknowledgement. Okay. Next is simple loan agreements or mutuum. A loan agreement is a written contract whereby one person or entity delivers money or another consumable thing to another person or entity who is bound to return the same amount of the same kind and quality either in demand or at a fixed determinable time. So this simple loan agreement is more formal than the promissory note. Okay. The purpose of this is that the obligation of the borrower to pay the equivalent thing only and not the identical thing because the borrower acquires ownership thereof, and the obligation of the lender to furnish the loan. This loan agreement is a bilateral contract. Okay. Unlike in the promissory note, that is a unilateral act of the borrower or of the debtor that the borrower is promising to pay the creditor. However, in these simple loan agreements, this is a bilateral contract. There's also an obligation of the lender or creditor to furnish the loan. Okay, so these are the elements. The heading, the title, the parties, okay, the body, okay, so almost the same as the first one, okay? So, kayang-kaya nyo yan, no? Halos magkakamukha lang din naman lahat. Okay. So, signatures of lender and the borrower, signature of at least two witnesses, and then, of course, acknowledgement. So, this is an example of a loan agreement. So, this is more formal. Okay. So, memorize, no? Know all men by these presents. So, memorize that phrase, that first phrase. Okay, memorize that. Because you will encounter that know all men by these presents, no? You will encounter that in succeeding legal forms just like in other contracts or deed of sale. Okay, so ma-encounter nyo ulit yan. So memorize that. So write the date this agreement is entered into and the place of execution, the name of the lender. Again, if the name of the lender or name of the borrower or name of the parties, okay, are not indicated in the bar question, just leave it blank or put a parenthesis, just like in our example, and then put the words name of lender, okay? Of legal age, Filipino with address at, okay, blank. Again, if there is no address indicated in the question, do not write any place, okay, to avoid avoid any distinguishing marks, okay? So, hereinafter referred as the lender. Then, name of borrower, Legal age, Filipino, with address of the borrower, referred to as the borrower. Okay, so each of the lender, okay, party in singular, parties collectively. And then witnesses, okay, the amount of loan, and then the terms and conditions. So you need to know how much the loan, the purpose, the interest, payment, okay, application of payment, what else, penalties and default, attorney's fees and costs, non-waiver of rights, governing law, and entire agreement. Okay, another tip, you don't need to memorize everything. Just know the essential elements. Okay, you don't need to memorize this in verbatim. Napakahaba, napakarami niyo i-memorize. Okay, just familiarize yourself. And then, of course, you need to know the essentials. Like, for example, the amount, the purpose, and then if there's a stipulation of interest. Okay, and then the manner of payment. Okay, what else? The signature, no? Signature of the lender and the borrower, and the sign in the presence of at least two witnesses. And then lastly, do not forget, okay? Do not forget to write the word acknowledgement. Again, if you still have time, write in full, okay, the contents of the acknowledgement. The main difference between a promissory note and simple loan agreement is that in the former, in the promissory note, the borrower executes a single written instrument promising to pay the lender, while in the latter, the simple loan agreement, both the lender and borrower execute and sign the instrument. So that is a bilateral contract. So the loan agreement is more detailed, no, as compared to the promissory note. A loan agreement is perfected upon delivery of the object of the loan. A promissory note may evidence an already perfected loan or a promise to pay an obligation in the future. Okay. So our next topic, okay, would be demand letters. Okay. So I will cut our discussion shortly, and we will be discussing demand letters in my succeeding video. Okay, so I will cut this short and stay tuned to the next videos that I will be uploading soon, continuing our discussion on practical exercises. And the next lecture will start with demand letters and the rest of the coverage of your bar syllabus. Okay, so thank you for listening. And you know my socials. You may reach me via Telegram. You may follow me on X or Twitter. And then you may follow me here on YouTube for other videos that I will be uploading soon. Okay, so thank you and good luck, and always pray. Okay, always pray before you start your review. Always pray before you answer any questions. Okay, so pray for God's guidance and wisdom.